This is part 10 of the revision lectures on arbitration. So now that we have looked very briefly at what the other three main types of ADR are about, in this video we are going to finally begin considering arbitration, which is the main topic of these revision lectures. So from now onwards, we're going to be looking very closely at the arbitration proceedings and the processes involved in an arbitration proceeding. However, before we delve into the details, in this video I'm going to provide a very brief overview of what arbitration is, and in later videos we're going to have a closer look at arbitration. So, talking about the meaning of arbitration, first and foremost, please note that arbitration is an adjudicative dispute resolution process, much like litigation. However, unlike litigation, arbitration is an out-of-court, consensual form of dispute resolution which is reached with the help of an arbitrator, and the solution is usually binding. Now, this point is very important because in contrast to the other three forms that we just discussed, that is negotiation, conciliation, and mediation, arbitration is basically a process in which the solution is binding. So, once the decision has been reached by the arbitrator, then the parties do not usually have an option to back out from that decision. By the way, in the previous video, I told you that in mediation, the third party is termed as the mediator, and in conciliation, the third party is termed as the conciliator. And I had left you to think about how we address the third party in arbitration proceedings. And right now, I just mentioned the term arbitrator, so that gives you the answer to that question. One more important point to remember from this video is that arbitration is based on an agreement between the parties, and as a consequence of this contractual basis of arbitration, it is not every dispute that can go to be referred and solved through arbitration. So remember that there is a contractual basis of arbitration, and this means that not every dispute can be resolved by means of arbitration. In other words, there has to be an agreement between the parties, and the agreement should be that the parties agree to refer the dispute or their differences to an arbitrator in order to reach a decision. Now, in the later videos, we are going to consider all of the major requirements for an effective reference to arbitration. However, please note that an agreement to arbitrate may be made either before or after the relevant dispute has erupted, so it's not necessary that this agreement should have been reached prior to the dispute arising. So, in some instances, there may be a pre-existing arbitration agreement, so that when a dispute arises, then in that situation, that pre-existing arbitration agreement can be used in case one of the parties is trying to avoid a reference to arbitration. However, like I said earlier, this is not necessary. There is also the possibility that there is no prior arbitration agreement that has been reached between the parties, and instead, once a dispute arises, it is only then that the parties want to enter into an arbitration agreement.